My name is Jeremy Grimaldi. I'm a crime reporter in Toronto and the surrounding GTA, and I'm hosting today's chat with Shakir Rahim, who's the Director of Criminal Justice Program for the Canadian Civil Liberties Association. Welcome to True Patriot Love. How are you today?
Thank you for having me on. I'm doing well.
Yeah. So could you tell me a bit about who you are in terms of your working life and a bit about what you do?
Absolutely. So I'm a lawyer and director of criminal justice for the CCLA. And my job is to advocate for laws in Canada that uphold all of our rights under the Charter. And we do that in a few ways. We sue the government on certain issues. We intervene in major cases before the Supreme Court of Canada. We attend Parliament and talk to lawmakers about proposed legislation. And we do research about topical issues like the bail system.
And your focus, I guess, is our, as in Canadian civil liberties. What does that entail in your viewpoint?
Well, I think it starts with the rights that we have under the Canadian Charter of Rights and Freedoms, one of which, Section 11E of the Charter, is the right not to be denied bail without just cause. And so any right that's in the Charter or freedom that's in the Charter is one that we stand to uphold and protect. And of course, we do that also mindful of the different kinds of policy considerations that matter, including public safety when it comes to the conversation around bail.
Yeah, and public safety, I guess, will be on tap today when we talk about this issue. It's definitely got people talking. It's had people talking for quite a while now. And there is concern out there. I know that from my work and my personal life, it does come up quite often. And I was wondering if you could take us back to when this really started.
Sure. I can maybe take us back even further in time to how we even arrived at the bail system we have today. So, for most of the 20th century, there was not much in the way of established law that applied to how bail decisions were made and why they were made. And in the 1970s, there was a significant amount of research that was conducted by some leading scholars about the bail system in Canada. And that research led to a lot of findings. A significant one was that there were many people who might be suitable for release, but couldn't be released because they were too poor to afford the cash that they were required to put up. So in the 1970s, Canada passed something called the Bail Reform Act that sought to ensure that bail was more accessible, but that there were still important considerations around when it could be denied, for example, on safety-related grounds, and the conditions that could be applied when somebody was released. And around that time in Canada, around about 25%, 20%, since we started collecting the data in the early 1980s, of people in provincial and territorial jails were people in pretrial detention. So many decades later, the CCLA published a major report on bail in 2014. And that report found that the percentage of people who were in pretrial detention had markedly increased in Canada. And right now it's at a record level of 76% of people in provincial and territorial jails. Now, at the same time, as I think you alluded to, we have seen a rise in headline stories and events where somebody may have been out on release and allegedly reoffended. And that's kind of driven this conversation that we have a really lenient bail system and that a lot of public safety issues are because bail is too easy to obtain. And so I think that's where we are right now in terms of the public debate, if you will, and kind of how we got here on a really high level in the bail system.
When I look at the issue of bail and how it's come to grow or at least morph in Canada. Do you see that things are changing, or do you not agree with that assessment?
Well, I think that one of the challenges we have actually is the absence of good data about the bail system. So if you brought in, let's say, the Minister of Justice or a provincial attorney general, and you point blank ask them, how many people out on bail allegedly reoffended last year, they can't actually answer the question because Canada does not collect that information. And so, you know, we have been advocating, along with other groups, for quite a while now that we need to collect better data. We need to know, how many people are allegedly reoffending, what kinds of offenses is that occurring under, what percentage of people out on release does that apply to? And we need that information to ensure that any changes we make to the bail system are grounded in evidence. And they'll address the cases that we are concerned about, but they also won't erode, the important right that is the right to reasonable bail. I'll just briefly mention, I think it's important to remember that before evidence is heard, before any arguments are made in a case, before a judge or jury has passed judgment, right? So someone's accused you of something. Bail is really all that stands between an innocent person and a prison cell. And so for us, it's an important right because it protects people's liberty before they've been convicted of anything. That doesn't mean that there aren't certain restrictions that can apply, but that when we tinker with the system, we need to know that we're not eroding that protection for people who can be released in a way that is safe for the community.
Sure. I've definitely seen a rise in the number of police forces that are announcing that people charged have been on recognizance, have been on bail. And as a result, readers and citizens are seeing this. What do you say to people who read stories like one that I wrote recently on a young man who committed a murder? This is in 2022. And it was found during his sentencing that he had broken his recognizance 7 times and was let out on bail again and committed the murder days after. It's cases like this that I would imagine people shake their heads at.
Well, first of all, I think it's quite right to reflect on those cases and ask the hard questions about public safety in the bail system when they arise. That is a concerning case, and it is one we should talk about. I think what's important is that when we then take that next step of saying, how should we change the bail system or how should we modify it, that we have that information. So maybe we say, okay, there's a certain kind of set of offenses or set of prior violations of a release order or whatever it might be that show there's a significantly higher risk when on release of not complying with conditions. And then we tinker the system to respond to that. So I think that that's a really legitimate question to ask. I think where it veers into challenging territory, right, is where on certain cases, people and politicians and sometimes police services react to say, well, that's the kind of case where no one should get bail, or this shows we shouldn't have bail for this kind of offense. I'm sure you're familiar, for example, with the story of Umar Zamir in Toronto. Mr. Zamir was for listeners who might not know, family man who was out on the town with his family. And several people approached him while he was in his car in a parking garage in plain clothes. And he panicked. He had a pregnant wife, accelerated his car away. Turns out those folks were undercover police officers. He was charged with first-degree murder. And he was released on bail. And at the time, everyone kind of pointed to that. And they said, well, that's why, no one like that should be getting bail. We shouldn't have any bail for murder. And in fact, the Ontario government has proposed abolishing bail altogether for a certain set of offenses. Mm-hmm. But he was found not guilty. It was widely seen that there were some pretty big problems with police officers' testimony on the stand. but there wasn't really much in the way of reflection from some folks about their initial comments. So I only mention that to say that it is why we really need this data and this information, so that we ensure that people like Mr. Zamir, who were rightly released, are, but that in other cases we can make the kinds of interventions necessary to prevent future harm to people.
Sure. That's a great case to bring up. I remember it well. And yeah, it's important to know both sides, 100%. But like, for example, if you're talking to like a layman on the street, do you think it'd be unreasonable for someone to say, okay, if you're charged with gun offenses, or if you've been found to be holding a gun or have a gun that's had a scrubbed off serial number, for example, that you should be held?
Well, let me give an example of why, even in that kind of weighty situation, you need the discretion of bail. So there was a shooting down at near, I believe it was Sudbury and Queen Street in Toronto. It was either this year or late last year. And very publicly, several arrests were announced of people at the scene. This was at a music studio. And there were a series of gun possession charges that were laid. And only a few weeks later, several of those charges were withdrawn by the Crown because there was no reasonable prospect of conviction. And some of those folks were also on pretrial release. They got bail. So why, might you ask, does it make sense for such a weighty allegation, an offense, to still have bail as a possibility? So often what happens is police might arrive on the scene, right? And they may not have time to figure out who actually possessed what. There's a bunch of people, there's a gun, there's different ways to have possession. So you can have what's called constructive possession, where you might not be holding the gun, but it's in the room next to you or in the room. And so you're connected to it in some way, or you knew about it. There's a lot of uncertainty at that stage. So often there might be a bunch of charges laid, but then there's more investigation, or there is further information brought to light. And it turns out that person charged with possession, clearly there's not enough evidence to support a finding of guilt. And that information can also come out in the bail stage, because they look at, what's the evidence, what are the nature of the allegations. So the reason I mention that is to say that certainly there might be certain gun possession cases where, because of someone's record, the nature of the facts, and so on, pretrial release is not warranted. But because of the kind of stage of the criminal process you're at, it's not like each case is a slam dunk or even close to a slam dunk. And so that's why you need that room that, okay, maybe this person can be released, maybe they have an ankle monitor, maybe they're under house arrest, but it's not quite the same as we should categorically say anyone charged with that offense should never be releasable.
Sure. Yeah, that makes sense. I often hear about it in a car. 6 people, 5 people in a car, 1 gun, everyone's charged.
Exactly.
But I mean, then, so a fair argument. But then someone may say, well, what about guys like the story I just mentioned? A young gentleman, it breaches his recognizance 6 times and is then released again. How does that kind of stuff happen?
Well, let me provide 2 thoughts on that. So, first off, in any bail decision, right, a judge has to provide their reasons, and sometimes those aren't publishable until the case is concluded, to not prejudice the actual trial proper. But we can go and look at the reasons that are provided for release in that kind of situation. So I'm not familiar, or I guess none of us are yet, with the specific rationale there. But that would be, where we can find the why. And those decisions are also subject to appeal by the Crown if they wish, if they disagree with the judge's finding.
Yeah.
One of the challenges, I think, so, you cite that example, and I agree with you that it does cause some concern, serious concern. But what we don't hear about is all the cases where someone is denied release. So, as I mentioned, right now, we're at a record level in the country when it comes to pretrial detention. In Ontario, it's over 80% of people in our provincial jails are in pretrial detention. So the reason I mention that is that there are a lot of cases that we don't hear about where people are in fact denied bail. And so it's not to minimize these other cases that we're hearing about in the headlines or the one you referenced, but that to really get an accurate picture of what's going on, I think requires us to also think about all of those cases we don't hear about where somebody was not released, and those cases where somebody was released, even on a serious offense, but never allegedly reoffended. Now, all of that is to say that I would not be being truthful if I said there is a way to fully minimize risk, right? There is an element of risk in any system, unless you say as soon as you're charged, you're locked up. So there is some element of risk, but how do we ensure that level is minimized as much as possible so that we have a system that, protects the presumption of innocence, but as you say and note, at the same time, ensures that we have protection for public safety. And, not to sound like a broken record, but that brings us back to that data point, is that we need to be able to understand what's going on in the system to make those kinds of changes.
Yeah, 100%. I mean, I guess it's difficult for people because, as the public, they're saying, well, the risk you're minimizing is the risk to innocent people who may have done nothing wrong and don't deserve to be the subject of violence, for example. But so that's why I guess the bail system becomes such a sensitive topic with people. But as you say, it's important. It's vital that a democratic society has the means to allow people to achieve bail because they haven't been nothing's been proven against them, and that's the cornerstone.
Absolutely, and again, it's not to say that there are cases where we have to draw the line, right, and say actually the risk is too high here. So our position isn't we have a right to not be denied reasonable bail without just cause, not a right to bail in every case. So I think it is important we recognize that public safety is part of the conversation, but as you say, it can't be the only part. Now, I'll give you another example of kind of where that plays out, right? So
Please.
We know that you can only be convicted of an offense if you're guilty beyond a reasonable doubt, right? Because we say, look, we don't want innocent people to be convicted of an offense and serve all this time in jail for something they didn't do. So we've set the bar pretty high about what we got to prove to send someone to jail. Now, you might say, well, maybe it's too high. Let's lower that to it's more likely they did it or not, right? You could have a society that did that, but then you'd have a lot more cases of people who were innocent who go to jail, even if there might be some public safety benefits. So it's a really challenging balance of how do you ensure that we protect these rights, but also ensure the public is safe, and that's why you need that evidence-based approach. If we're just going off of, well, here's how I'm feeling about how the system is, or here's the, this particular story that was outrageous, we kind of miss all that really important nuance and deliberation.
So, I mean, I guess lack of statistics means that we don't even know if people are being irrational in saying the bail system is in crisis right now. Is there any information to tell us one way or the other if it's an irrational thought that the bail system is in crisis, or some of the popular opinion truthful in that things have changed, things have gone wrong? What's your thought process there? And also, furthermore, is it okay to tell people you're wrong when they feel something and they feel like they see something? Is it okay to say, no, that's not actually what's happening, when, again, we don't really know?
Well, I have a few thoughts. First I would say, I, like any other person, when you hear about something horrific that's happened and you look at the circumstances and you see maybe a decision to release was part of that, feel concerned. And I think that's a really legitimate feeling to have and to want action on that. So I would not for a second dismiss the legitimacy of that reaction. I think it is a fair reaction. Um, I think that the problem is that our political leaders, instead of then saying, okay, we see there are issues that are causing concern to the public, we gotta get off our rear ends and do the hard work to figure out how we address this, have not taken the steps necessary. I mean, you can go back to the parliamentary hearings in the 1970s and 80s, and legislators were asking government officials, where's the data? Where's the information about the trends of the system and how we understand what you're proposing? And they're like, we don't have it. Well, I'll quote you, the current Minister of Justice. This is what he said. He said, it's not as though there is an effective national data set that will demonstrate conclusively that certain changes will or will not have a desired impact. And he's speaking about his own bill right now, the bail reform bill at the federal level. And, we, CCLA, we met with his predecessor and the predecessor before him, and others met, and we've all been saying, get your act together, collect the data so we can actually make policy that we understand what it's going to do. So I think that there's been a bit of a sleight of hand where instead of elected officials being held accountable for not doing the work they should be doing, they're actually willing to just say, well, I don't know what is going to happen here, but I'm content eroding access to bail for everyone in some hope of achieving something. Even the legislation that's been proposed right now, Bill C-14, you've heard people talk, well, it's about repeat violent offenders. All the new reverse onus provisions, that's when you got to prove why you should be released, as opposed to the state, they apply to people regardless of their criminal record. They don't have to have a prior conviction. They don't have to have a record of violence. The offenses don't have to involve violence necessarily. So anyone who's an alleged first-time offender now for a bunch of these offenses is going to face a reverse onus. And so that's what I would say the public should really be calling upon their elected officials to do, is to do that hard work so that we have real solutions to what they're feeling.
So are you in opposition of C-14 and the reverse onus?
Yes, we are. And the reason I just cited is one example why, is the fact that it's not actually restricted to the kinds of cases that we've been told are the bill's targets.
Gotcha. Yeah, so I'm assuming that you have a different approach that you'd take. Do you see that there's a problem, or is that not even something that you admit to or want to venture down that path?
Well, I'd say we have kind of almost two sets of problems. So, as I said, I do think that the types of headlines that we've seen, where someone is released as allegedly reoffended, we need to understand what is the frequency of that relative to overall release numbers. What are the conclusions we can draw about, is there a type of offense or type of prior history that can inform risk of releasing someone, or the kinds of conditions? So we support taking those steps. And once we have that information, legislating based on it. So that is our position. It's not that there's no room for legislative change, but it has to be supported by that information. On the other hand, though, it is also true that our bail system has some major problems in terms of, for example, conditions in pretrial detention, right? So let's say we even do deny more people bail. At the Toronto South and other facilities in Ontario, there are regular long-term lockdowns, significant overcrowding, breakouts of various diseases. I mean, judges have written, over 100 decisions about the conditions there. And that's also a public safety risk, because if you take someone and you put, so now they're disconnected from any employment, family, community, you put them somewhere where they're in close quarters, they're dealing with all kinds of different physical or mental health challenges now, and then they come back out into our community. That's not setting anyone up for success, right? And they might not even have been convicted of anything during that whole process. Similarly, right now the government's proposed, as you likely are aware, doing away with the hard ceilings on how long a trial can take. Right now that's 18 months in the provincial court and 30 months in superior court. So again, if you're saying that, or if the government is saying that, hey, we want to deny bail more, but also, by the way, we want to get rid of the ceilings for how long you're going to spend in jail before you have your day in court, well, that's a pretty big problem, right? So if they're going to be taking these steps, they should be ensuring that they're funding the system properly so that people are now not going to be spending even longer in pretrial detention. So it's that I think we do see issues, but I think we see them from several different angles in the criminal justice system.
Yeah, I almost every judgment or sentencing I read nowadays has some element of the conditions in custody, and you see credit given to seemingly almost everyone because of the conditions in these jails and prisons. And you kind of wonder when that's going to stop. That's a whole nother issue. But it was a real pleasure speaking to you and better understanding the issue from all sides and the great work that you guys do over there at CCLA. And I'm guessing we're going to see what the changes are if they make it through, and it'll be interesting times ahead.
Absolutely. Well, look, thanks for having me on. I know this is it's a complex subject to kind of have a discussion over, and I'm really glad we're able to kind of have a productive exchange of views on it. So really appreciate that.
Yeah, it was a treat. Have a nice day.
All right, you too. Bye-bye.
Bye-bye.